On the 16th of September 2019, I convicted the accused, Mr. Nicholas Ninow, of one count of rape, in that he sexually penetrated a completed more than once, who was also a child under the age of 12 years. One count of possession of drugs as contemplated in Part 3 of Schedule 2 of the Drugs and Drug Trafficking Act 140 of 1992, and one count of defeating or obstructing the administration of justice. After the conviction of the accused, as stated above, Mr. Albert, who appears on behalf of the accused, requested the adjournment of the matter for purposes of obtaining a psychiatric report and a probation officer's report. Mr. Ngobeni, on behalf of the state, also made a similar request to obtain a victim impact report. The accused is still represented by Mr. Albert from the Pretoria Justice Center, whereas the state is still represented by Ms. Ngobeni from the Director of Public Prosecutions. The accused testified in mitigation of sentence, and his testimony can be summarized as follows. That 3 months before this incident in 2017, he stopped taking his medication as he is diagnosed with bipolar disorder and started using drugs and alcohol. Before the incident, he was constantly for 3 days using drugs to the extent that he could not even go to work. And that gravely upset his fiancé. Despite his fiancé pleading with him to go to work, he did not do so. Instead, his drug dealer came and delivered drugs for him so that he can have further consumption of drugs. On the day of the incident, he left home under the pretext that he was going to work, but he didn't go to work but consumed more drugs and eventually ended up being at Dros restaurant in Silverton. The first thing he did when he arrived there was to run to the bathroom and consume more drugs. Inside Dros, he did not remain where he was initially seated and went to sit outside the restaurant as it was hot inside. He then met a gentleman who was unknown to him at the time called Johan. As he was desperate to talk to any other person. He then consumed alcohol in the company of Johan and in between used drugs. What he can remember is that he ended up sitting in the female bathroom, closed the door of the toilet cubicle, and then started consuming drugs. He cannot remember what further happened, and nothing mattered to him, and he was high on drugs. And then he ended up making a mistake. Sober-minded, he could not have done what he did on that day, let alone getting physical with any person. He started using marijuana, also known as dagga, when he was 12 years old. His experience with chemical drugs was when he was 13 years old. He used to consume drugs with his mother and described their relationship as that of a brother and a sister, the reason being that his mother was very young when she gave birth to him. His mother introduced him to cat, and that was the beginning of his journey to become a drug addict. When he was 17 years, doing grade 11, he was admitted to the drug rehabilitation center, and at the end of the year, he managed to pass his grade 11, as he had a tutor who was assisting him with his studies. 3 months after his discharge from the rehabilitation center, he was back to drugs, and from there he was in and out of a drug rehabilitation center. He relapsed mainly for the fact that his mother was again back to his life after they were evicted from their home in Cape Town. At that stage, accused was staying with his grandmother. He admitted to taking drugs whilst in prison, awaiting the finalization of this matter, and according to him, it was for approximately 20 times. He feels sorry for his fiancée and his son, who is currently 10 months, and was born while he was in custody for this matter. He regrets that his son will grow without seeing him as his father. He wrote a poem to the complainant, as words cannot describe what he has done and what he is going through. He also penned a letter to the family of the complainant apologizing for his conduct. In cross-examination, it was put to him that he is trying to put blame on drugs and alcohol that he consumed on the day of the incident. And in his answer, he said that when he's sober, he could not have done what he did on that day. The accused was referred to the complainant's JATH, which gives out her length and weight, and was asked why did he prey on such a tiny child, and the accused's response was that he does not know what happened. Ms. Marina Janis, a clinical psychologist, compiled a pre-sentencing report which was admitted into Evidence Exhibit G. In that report, she gave the background of the accused and indicated that the accused mother fell pregnant when she was only 15 years. Accused mother and a partner are also on drugs. That the accused was physically and sexually abused when he was still a young child. The accused also attempted to commit suicide on various occasions and was eventually admitted to a psychiatric hospital. Accused passed grade 12 without repeating grades, and whilst in grade 11, he was admitted to Healing Winds Rehabilitation Center for Substance Abuse. Accused was employed at different Vodacom branches during 2017 and 18, and as a salesperson, even though it was not stated in the report as to how much he was earning at the time. He did not personally have friends, but he had several love relationships, with the last relationship being when he was arrested for the current matter. A child who is now 10 months was born of that relationship. Accused started abusing drugs when he was 12 or 13 years old, using cat, cocaine, crystal meth. That led him to be admitted to different drug rehabilitation centers. At Demna Psychiatric Hospital, his stay there was terminated as accused continued to use substance. He promised to kill himself if he is sentenced to life imprisonment. He does not have sexual fantasies towards children, and even though admitting to watching adult pornography, he never watched pornography which involves children. His fiancée informed Ms. Janis that accused after using cat he becomes sexual, but he has never forced himself into her sexual. Ms. Janis found that the accused's childhood circumstances and the child abuse he suffered played a significant role in his development, behavior, and psychological functioning. She further stated that despite his abusive past, she did not find any pedophilic disorder in the accused. Her collateral sources also denied the accused ever being sexually attracted to children or watching child pornography. But the fact that the accused chose a child as his victim is a case for concern, and that aspect needs to be closely monitored. The accused is a first offender and does not have a history of perpetrating violent and serious offenses, save for stealing from his grandmother's house to support his drug addiction. The accused is sincerely remorseful based on his interactions with the accused and her clinical observations of the accused, also having insight into his action and its consequences. In cross-examination, when asked whether she regards the accused as a danger to society and that he is not a candidate for rehabilitation, as in the past he was admitted to a rehabilitation centers only to relapse, the response was that if accused can adhere to his psychiatric medication, there is a great possibility that he can be rehabilitated, but there is a great risk of him reoffending if he does not adhere to his psychiatric medication. Ms. Dilith Kelder, a social worker employed by the Gauteng Province Social Development, as a probation officer, complied a probation officer's report on behalf of the accused. In terms of the report, the accused was born on the 16th of February 1998, which makes him to be 21 years old. At the time of the commission of the offense, the accused was 20 years old. In a report, she gave the accused version of the offense. In the report, she stated that the accused told her that he put his fingers in the complainant's vagina and realized that it was wrong. He tried to put his penis in her mouth. As he was busy trying doing that, the complainant's mother arrived. Accused does not have previous convictions. Accused is the only child of his parents, and his mother gave birth to him when she was 15 years. His mother is also a drug addict. The accused, as a child, was both physically and sexually abused. Accused grandparents described the accused as a wild child, undisciplined, very much beaten when he was growing up. At the age of 4 years, accused knew that his parents were doing drugs. The accused was eventually adopted by his grandmother, who then raised him as her own child. When accused was 12 years, his mother introduced him to CAT. Accused is currently unemployed and as is in custody awaiting finalization of this matter. She also confirmed what Ms. Janice testified about that the accused has been diagnosed with bipolar disorder. She also confirmed that the accused is still doing drugs in prison. She also found that the accused is sincerely remorseful. She then recommended a life imprisonment sentence to be imposed on the accused. Pauline Gericke is the grandmother of the accused and confirmed that he has been staying with the accused since he was 8 years. The accused has two personalities, when he's on drugs and when he's sober. As a sober person, the accused is a good person who is overprotective, who can take a blame for a thing that he did not do. But on drugs, he's a totally different person from that she raised. She also confirmed that the accused was introduced to drugs by his mother when the accused was only 12 years. And this will happen every time when the accused will visit his mother in Krugersdorp. When the accused was introduced to drugs by his mother, he was together with a friend who were drinking for the whole night, and then the accused mother gave accused care so that she can sober up. There was a stage when accused was free from drugs for a period of approximately an year, and then went back to drugs. Ms. Gericke also confirmed that accused is not a pedophile, and if he could not have stopped his psychiatric medication, he could not have went back to drugs. She conveyed an apology to the family of the complainant and expressed how she is sorry for the accused. Ms. Gericke further testified that the court must not only perceive the accused as a rapist, but it must also consider that there is another side of the accused. After the testimony of Ms. Gericke, the defense closed its case and did not call further witnesses. The state witness in the sentencing process was Ms. Karen Botha, a forensic social worker in the employ of the South African Police, who compiled a victim impact report. Ms. Botha dealt in her report with the trauma the complainant in this matter suffered and the impact of the offense on the complainant. The complainant verbalized to her that she sometimes still sees the accused and she can remember the color of his hair and eyes. And when he sees the accused in her memory, she will have nightmares. She sees the accused every time she goes to bed, and at times she will just try not to imagine the accused and at times she will just try not to imagine the accused and what he did to her, just to try to fall asleep. Her nightmares makes her feel afraid and scared. She's scared that the accused will come to her room, like he did in the restaurant bathroom. She remembered the accused told her that when she tells anyone of what happened, he will kill her. She's now scared mostly of men and restaurants. The complainant always conceal her identity because of the publicity this matter has attracted, and she feels that if her identity is made known, she will not be able to attend normal school, but she needs to be homeschooled. The trauma experienced by the complainant is also extended to the complainant's immediate family, and they have put their faith in the justice system. Ms. Botha finally found that the complainant, as a survivor of rape, will have ongoing problems with her self-esteem, social interaction, intimacy, trust, and personal boundaries. She will further, in all likelihood, continue to face emotional, psychological, physical, and psychological difficulties in her life as a result of the rape she experienced. S.S. Tereblanche, in his book, A Guide to Sentencing in South Africa, 3rd edition, at page 151 to page 152, lists the following as general principles of sentencing. 1. The sentencing court has to impose an appropriate sentence based on all the circumstances of the case. The sentence should not be too light or too severe. 2. An appropriate sentence should reflect the severity of the crime while at the same time giving full consideration of all mitigating and aggravating factors surrounding the person of the offender. 3. An appropriate sentence should have regard to the interest of society. 4. The interest of society and the purpose of sentencing are deterrence, prevention, rehabilitation, and also retribution. Purpose of deterrence is to deter the offender from reoffending and also deterring other would-be offenders. 6. Rehabilitation should be pursued only if sentence actually has the potential to achieve it. 7. Mercy is contained within a balanced and humane approach to consideration of the appropriate punishment. Triad, as explained in the seminal case of State versus C, consists of the crime, the offender, and the interest of the society. It is a well-known phenomenon that rape is a most degrading type of offense, as it robs its victim their right to privacy and human dignity. It is worst when committed against the most vulnerable in the community, being young children. The complainant was only 7 years when she was violently sexually assaulted by the accused. Apart from being 7 years, she was also a very tiny and small person with a weight of 21 kilogram and a height of 128 centimeters. What was a happy family outing to Dros restaurant became a nightmare for the family of the complainant. Nobody expected that the complainant will be degraded in a manner in which she was degraded by the accused. The complainant was violated at a place where everybody thought that their children are safe. The complainant is now scared of visiting restaurant and she's scared of being in the company of men. The accused violated a child that he was supposed to protect. As his grandmother said, accused is an overprotective person. This incident left the complainant with emotional scars. The incident did not only affect the complainant alone, the family of the complainant was left traumatized because of this rape incident. Mrs. Ngobo, who was a childminder at Dros restaurant, had to vacate her employment as she could not cope with what happened to the complainant. She felt that she was a failure as she failed to protect the child she was entrusted with. The mother of the complainant does not wish any parent to experience what she experienced on the day her child was violated. The accused is a very young person who is currently 21 years. When this incident happened, he was 20 years old. At the time, the accused had a fiancée who was pregnant with the accused child, and accused had a good employment as a sales representative. Accused was sexually abused when he was 4 years by a family friend. He started smoking daga at the age of 12. When he was 13 years, his mother introduced him to chemical drugs. That was the start of the journey of accused to drug addiction. Accused since then, he was admitted to psychiatric hospital, drug rehabilitation centers, only to relapse after his discharge from such centers. Accused is content that his child, who is currently 10 months, will grow without a father figure in his life, as he will be doing time in prison. Accused before the incident was on medication, and he stopped taking medication with the sole purpose of returning to drugs. 3 days before the incident, he was constantly using drugs and consuming alcohol in between. On the day of the incident, he also used drugs and alcohol. Accused regrets his action and stated that if it was not for alcohol intake and abuse of substance, he could not have done what he did to the complainant. The accused, from his early life, he lived a broken life, and he appears to me to be a broken person. The person who was supposed to have protected him, guided him, nourished him, introduced him to drugs at an early stage of his life. Gender-based violence in this country is pandemic. The day hardly goes by without the reading in the newspapers or the televisions about women or children being raped and killed. It is unfortunate that the complainant in this matter is a statistic. The annual statistics shows that gender-based violence is on the rise. The government, in its endeavor to curb such rise, is conducting a number of campaigns to educate the communities about scourge of gender-based violence. Millions of rands are pumped into such campaigns by the government, but it appears that such calls falls into deaf ears. 16 days of activism for no violence against women and children is an annual event which is meant to conscientize the communities about gender-based violence. In the light of the pandemic, the society is putting its hope in the judicial system. Courts must not be shy to impose sentences which will deter would-be offenders of commission of offenses similar to the one accused committed, and also deter the offenders. In the matter of State versus Mtlagaza in another 1997, Volume 1, SACR, page 505, Supreme Court of Appeal at page 518, paragraph E, Harams J.A. stated, the objective of sentencing is not to satisfy public opinion, but to serve public interest. A sentencing policy that caters predominantly or exclusively for public opinion is inherently flawed. It remains the court's duty to impose fearlessly and appropriate and fair sentence, even if the sentence does not satisfy the public. In this context, the approach expressed in State versus Makwanyane and another applies mutatis mutandis. Public opinion may have some relevance of the inquiry, but in itself it is no substitute for the duty vested in the court. The court cannot allow itself to be diverted from its duty to act as an independent arbiter by making choices on the basis that it will find favor with the public. Close quotation. The accused has been convicted of rape which results under Section 51 in bracket 1 of the Criminal Law Amendment Act, which provides, notwithstanding any other law, but subject to subsection 3 and 6, a regional court or a high court shall sentence a person it has convicted of an offense referred to in Part 1 of Schedule 2 to imprisonment for life. Part 1 of Schedule 2 of rape case, in rape cases refers to 1, rape when committed in circumstances where the victim was raped more than once, whether by the accused or by any co-perpetrator or accomplice. 2, where the victim is a girl under the age of 16. Accused was charged with 1 count of rape, even though he sexually penetrated the complainant more than once. It is tried that several sexual penetration following closely on one another should be considered as one charge for the purpose of conviction. But for purpose of sentence, the whole scenario changes and becomes rape more than once, as it was correctly decided in the case of State versus MM, 2010, Volume 2, SACR 543 at page 545, paragraph B to C. Section 51 in bracket 3 in bracket A of the same Act provides, if any court referred to in subsection 1 or 2 is satisfied that the substantial and compelling circumstances exist which justify the imposition of a lesser sentence than the sentence prescribed in those subsections, it shall enter the circumstances on the record of the proceeding and must thereupon impose such lesser sentence. The seminal judgment of State versus Malkhas, 2001, Volume 1, SACR 469, in bracket SCA, guide us how to approach and deal with the concept of substantial and compelling circumstances. However, the definition of what is substantial and compelling is absent in the Act and was deliberately left for the court to develop. Malkhas cautions us not to deviate from the prescribed minimum sentence for flimsy reason. The onus is on the accused to show that there are substantial and compelling circumstances. Mr. Albert, in argument, contended that this court should deviate from from imposition of the prescribed minimum sentence for the following reason. 1, that the accused is a first offender. 2, that he is relatively a young person. 3, that the accused is a drug addict, and on the day of the commission of the offense, the accused consumed alcohol and drugs. 4, that the accused has been in custody for 13 months awaiting for finalization of this matter. And 5, that he is remorseful. Ms. Ngobeni, on behalf of the state, contended that the accused failed to show the existence of substantial and compelling circumstances. The accused, even though branded as a drug addict, there is evidence that there are instances when the accused can live a life free of drugs. Ms. Janice, in her testimony, said that if accused can adhere to his psychiatric medication, there is a great possibility that the accused can be rehabilitated from drugs. The accused was in the past in drug rehabilitation centers only to relapse, mainly because of the fact he does not keep good company. However, what is disturbing is that despite the accused saying drugs are the source of his current situation, he is currently doing drugs in prison. The concept of rehabilitation, in my opinion, starts with an individual. The accused is not prepared to rehabilitate himself as he has shown in the past and now. I'm alive to the fact that the accused is a relatively young person. At the time of the commission of the offense, the accused was in a relationship and his fiancé was expecting a child. The child who was subsequently born when the accused was in custody in this matter. The court, in the matter of State versus Majiji, 2011, Volume 1, SSCR 40 at page 47, paragraph 14, stated, turning to the respondent's age, what exactly about the respondent's age tipped the scales in his favor was not elaborated upon by the learned judge. During the course of the judgment, reference was made to the respondent's relative youthfulness without any attempt at defining what exactly that meant in respect of this particular individual. It is tried that a teenager is prima facie to be regarded as immature, and that the youthfulness of an offender will invariably be a mitigating factor, unless it appears that the viciousness of his or her deeds rules out immaturity. Although the exact extent of the mitigation will depend on all the circumstances of the case, in general, a court will not punish an immature young person as severely as it would an adult. It is well established that the younger the offender, the clearer the evidence needs to be about his or her background, education, level of intelligence, and mental capacity, in order to enable the court to determine the level of maturity and therefore moral blameworthiness. Close quotation. The accused raped a very young, defenseless child. When the mother of the complainant was shouting her name, looking for her, accused threatened to kill her if she responds. The accused, after he was caught, he flushed the underwear of the complainant down the toilet. The viciousness in which this offense was committed rules out that accused was immature. All accused experts testify that the accused is sincerely remorseful. However, both aspects use the words regret and remorse interchangeably, which to me do not connote the same thing. The court in State versus Majiji, in bracket Supra, defined what remorse is when it stated at paragraph 13 that remorse was said to be manifested in him pleading guilty and apologizing through his counsel, in bracket, who did so on his behalf from the Dros bracket, to both Ms. Kady and Mr. Kennon. It has been held quite correctly that a plea of guilty in the face of an open and shut case against an accused person is a neutral factor. The evidence linking the respondent to the crimes was overwhelming. In addition to stolen items found at the home of his girlfriend, there was DNA evidence linking him to the crime scene, pointing out made by him, and his positive identification at an identification parade. There is moreover a chasm between regret and remorse. Many accused persons might well regret their conduct, but that does not without more translate to genuine remorse. Remorse is a gnawing pain of conscience for the plight of another. Thus, genuine contrition can only come from an appreciation and acknowledgement of the extent of one's error. Whether the offender is sincerely remorseful and not simply feeling sorry for himself or herself at having been caught is a factual question. It is to the surrounding action of the accused rather than what he says in court that one should rather look. In order for the remorse to be a valid consideration, the penitence must be sincere and the accused must take the court fully into his or her confidence. Until and unless that happens, the genuineness of the contrition alleged to exist cannot be determined. After all, before a court can find that the accused person is genuinely remorseful, it needs to have a proper appreciation of inter alia, what motivated the accused to commit the deed, what has since provoked his or her change of heart, and whether he or she does not have a true appreciation of the consequence of those actions. There is no indication that any of these, all of which was peculiarly within the respondent's knowledge, was explored in this case. Close quotation. The accused wrote a poem to the complainant, a letter to a family asking for forgiveness. The letter and the poem never reached the intended people until the current sentencing process. To me, that is not remorse, but regret, as accused is aware that he is facing the prospect of a lengthy term of imprisonment. It is my considered view that the accused failed to show the existence of substantial and compelling circumstances. Accused pleaded guilty to the charges of possession of drugs and defeating the administration of justice, and I have considered the concurrent running of the sentences. In the absence of the existence of substantial and compelling circumstances, I'm going to sentence the accused in the following. May the accused stand up. Rape, you are sentenced to life imprisonment. Possession of drugs, you are sentenced to 5 years imprisonment. Defeating the administration of justice, you are sentenced to 5 years imprisonment. I order that the sentence in count 3 to run concurrently with the sentence in count 1, which is life imprisonment. Effective sentence is life imprisonment and 5 years imprisonment. The accused in terms of Section 50 of the Sexual Offences and Related Matters Act 32 of 2007, I order that your particulars be included in the Register of Sexual Offenders. Yes. The effect of this order is that in future you cannot be employed in the environment which involves children. That will be your sentence. What I do.
I say